party in this case charges the other with violating certain statutes of the Highway Traffic Act. It is the law of this state that a violation of any of the provisions of the Highway Traffic Act by a person operating a motor vehicle upon a public highway shall be prima facie evidence of negligence. This presumption of negligence, however, may be rebutted by evidence showing that the statute in question was not violated, or by evidence showing a reasonable ground for such violation. The driver of a motor vehicle whose vision is obscured by snow and wind or other atmospheric conditions must exercise care and caution commensurate with the situation. The factors to be considered when determining a driver's negligence are the speed and control of the vehicle, the extent of visibility, and the degree of care and caution required under the circumstances. It definitely appears that both motorists were driving at a speed lower than the maximum permitted under the Highway Act. But the fact that the speed of a vehicle is less than that permitted by law does not relieve the driver from the responsibility of reducing speed when special hazards exist with respect to weather, visibility, or highway conditions. It was the duty of each of these drivers to keep his vehicle in his own lane of the pavement. This collision could not have happened if each had done his duty in that respect. It is for you jurors, the judges of the facts, to determine where and how this accident happened and who was to blame, whether both drivers were guilty of negligence, which substantially contributed to cause the accident, or if a weather condition alone were responsible. Should you find that both drivers were guilty of violation, and the violation by each was a proximate cause of the accident, then neither party can avoid liability. And the statistical method would obtain as to expressions in numerical form. It is clear that while an econometric model gives some promise of success, its use is limited. There are many sources of error involved in its construction in addition to the simplifications already mentioned. We face a good many difficulties. We do not know, for example, exactly how fast families adapt their living conditions and expenditure patterns to be changed, to changed conditions. We do not know all the factors which influence business investment decisions. The greatest need in economic research today is not the study of relationships among global quantities. What is required is the study of the detail of daily economic life by the careful observation of families and firms. No econometric model is sufficiently accurate or reliable to serve as a sole guide to policy, even on a fairly short-run basis. The compounding that can occur when we turn our attention to the long-run projection of the economy raises the most serious questions about the usefulness of the method in this context. Nonetheless, at the present stage of development, the econometric model is a useful adjunct to other methods of analysis and forecasting. If it is nothing else, it is at least the most sophisticated method we now have at our disposal for disentangling the implications of actual economic events and of keeping our speculations consistent. A joint trial in this case resulted in the conviction of 5 co-defendants on a federal charge of conspiring to deal unlawfully in alcohol. On a federal, only the petitioner, Edward Larson, appealed. The principal issue is whether the trial court committed reversible error as against petitioner by admitting in evidence a confession of a co-defendant made after the termination of the alleged conspiracy. The trial court declined to delete references to petitioner from the confession, but stated clearly that the confession was to be considered only in determining the guilt of the confessor and not that of other defendants. For the reasons hereinafter stated, we agree that under the circumstances of this case, such a restricted admission of the confession did not constitute reversible error. In the District Court for the Southern District of New York, the jury convicted petitioner and 4 co-defendants of conspiring to possess and transport alcohol in unstamped containers and to evade payment of federal taxes on the alcohol. The co-defendants were Philip Harris, Hugo Mason, Joseph Hart, and Edward Peters. The government's witnesses testified that they had observed actions of the defendants which disclosed the procedure through which Harris, Mason, and petitioner supplied unstamped alcohol to their customers, such as Peters and Hart. The government also offered for use against Hart alone his written confession made in the presence of a government agent and of his own counsel after the termination of the conspiracy. The court postponed the introduction of Hart's confession until the close of the government's case. At the time, the court admitted it with an emphatic warning that it was to be considered solely in determining Hart's guilt and not in the determination of the guilt of any of the other defendants. The court repeated this admonition in its charge to the jury. The Court of Appeals affirmed petitioner's conviction. We granted certiorari, especially to consider the admissibility of Hart's post-conspiracy confession.
Little too fast.
200. But it was a tough case.